Okay, so I think we'll go ahead and get started. Welcome everybody. For anybody that didn't hear, this is our attempt at webinars for our focus events to see if they work for everybody. One, just as far as accessibility, and also, you know, how people like it if it's a better format. So we'd love any feedback you'd like to provide afterwards. Just so we have an idea of what works and what doesn't work. We want to make this as accessible to people as we can. So please feel free to share what you thought of it. As everybody knows, we've been dealing with the paid family medical leave program for the last year already as employers collect the premiums and have been reporting or trying to report to the state once the state was ready for them to do that since January of this year. So I'm going, as part of this, I am just going to do a refresher. I still have conversations with people where some of the things that have been going on, they're not fully aware of. And so we have found that it helps just to go back through some of the things that have already been implemented, just in case there's still a question around that. Unfortunately, the state put this in place and then didn't really have all the rules figured out. And actually they're still on phase 6 of 6. And that last rulemaking process will not be final until late December. So there's still a few things out there that we're not sure of. And we will do another update once that has happened. We're hoping to actually do that right before Christmas because the final rules are supposed to be issued December 20th. And our hope is to do a webinar that following week so everybody has all of the current information. And we also, unfortunately, expect that there will still be some growing pains as the state figures out how to deal with the benefits actually being processed. So we will continue to keep an eye on all of that. And as we can provide more information to everybody, we will do so. But we're always here to support you. If you have a question, feel free to give us a call and we'll do what we can to help. So as I mentioned, employers were supposed to have started collecting premiums for the paid family and medical leave as of January 1 of this year. And then also reporting the hours information and the wage information to the state on a quarterly basis. The state took a little while to get their reporting in line. And so the first 2 quarters were reported at the same time. And we just finished the reporting for quarter 3. So as of January 1 of 2020, employees will actually be able to begin collecting benefits for PFMLA. So the paid family and medical leave is a state-run insurance program similar to unemployment. It's being funded by both employers and employees, and the employees are paying the majority of the premium for that. Eligible employees are assured up to 12 weeks of leave as they need it. And in some situations, they may be eligible for up to 16 or to 18 weeks, depending on their needs. And there is a job protection component of the PFML. However, it's only in certain circumstances, which I'll cover a little bit later. So not everybody is entitled to that job protection. And I don't think that was necessarily clear early on, but they've cleared that up, or to the extent they can, a little bit more. So qualifying events in the situations in which employees can take PFML, there are 2 different types of leave. There's the family leave, which is to care for a family member with a serious health condition, the birth or placement of a child, or a military exigency. One thing to note here is that the definition of family is pretty broad. And this is where it also differs from FMLA because there's a much broader provision for the leave under the PFML than there is under FMLA. So your family can include your grandchildren, your grandparents, your siblings. I believe I read that it could include, you know, if there's somebody that considered you to be more of a parent figure, that if they needed you to care for them, that would be a sufficient event. And then there's also the medical leave for your own serious health condition. Oops. So to be eligible to take this leave, aside from having a qualifying event, the employee must have worked 820 hours during the qualifying period, which is the first 4 of the last 5 completed calendar quarters from their leave date. Their eligibility, it is portable across employers, so that 820 hours can be worked for numerous employers. It doesn't have to just be with one employer, and it can be part-time or full-time employment. And they must have worked 40 hours per week for 20.5 weeks to qualify. The other thing to keep in mind is there must be 8 consecutive hours of leave that they're seeking. So in other words, if you have a doctor's appointment that takes up an hour or 2 during the week, that would not qualify you for PFML. You would have to have 8 consecutive hours of leave. I did hear an example recently that related to a mother taking an 8-hour day to care for a child. And then because she had a doctor's appointment later in the week, and that ended up being 9 hours, that she could use the PFMLA for all 9 hours because she had the required 8 consecutive hours of leave. The other thing to keep in mind here is that employers are not administering this. Employers are not determining if there's a qualifying event or whether the employee is eligible for the leave or the benefits. This is something that the state is handling. So the claim will be made to the state and the state will make the determination. So the primary responsibility of the employers is to collect and remit the premiums, provide the required reporting to the state, and then the requirements around the job protection, if that is something that's available. So the benefits that are received by the employees is a monetary benefit, and it's a weekly partial wage replacement that can range anywhere from $100 up. There's a capped at $1,000 per week. And then there's the leave benefit component, and it's based on how much time is medically necessary. And it's up to 12 weeks in most cases, as I mentioned before, but it can go as high as 18 in limited cases if there's health complications related to pregnancy. And again, these benefits are not being paid by the employers. This is something that the employees request from the state. The state determines whether or not they're eligible, and then using the premiums that have been collected, the employees will be paid by the state. So the employee will file a claim for the leave directly with Employment Security. They do, however, have to provide notice to their employer if they're going to be taking the leave. So if the leave is foreseeable, they're required to provide 30 days written notice to the employer that they will be seeking that leave. If it's unforeseeable, then they must provide the notice as soon as practicable. So unfortunately, there are situations like, say, somebody's in a coma, they may actually not provide the notice until after the event has occurred. But as long as they do it as soon as they're able to, then that's sufficient under the statute. And then the Employment Security, once a claim has been received by the employee, will notify the employer that the claim's been submitted as well. And then they're going to be, Employment Security will verify the information that's been provided by the employee, whether it's a doctor's note indicating why the medical leave is necessary, and also to validate that the employee has met the hours requirements in order to receive the leave. So again, the Employment Security will handle all of that. They won't be seeking any additional information from the employer because they'll be basing it on the information that was reported previously by the employer. And then once the claim's approved by Employment Security will issue that payment directly to the worker. And the employee actually is filing this claim weekly with Employment Security, and as long as they're using the leave. If they do exhaust those benefits, then they have to wait for a new claim year. And the employer will also receive notice when the claim's either been approved or denied by Employment Security. One thing to keep in mind too is that they're still determining whether or not the employer will be allowed to receive information such as how much benefit the employee is receiving. So that we should know that in December once they've finalized those rules. Any questions so far?
I have a question or two.
Okay.
This is Jackie from Uniplex. Hi. How does this potentially overlap with L&I?
Oh, with work, you know what?
I got a good question, yay.
No, you did, Jackie. That's a good one. I was prepared for the FMLA questions.
And okay, so here's my next question too, is presently we have a, we require the use of PTO when people are gone policy. So is that something we maybe need to look at?
Can you repeat the first part of that?
So if we require the use of, we don't allow people to take unpaid time off if they have PTO available to use.
Oh, right. Okay.
How does that play with this? Is that
so I'll cover that a little bit later, but I can tell you that it's up to the employee how they use their those benefits. So if they, and frankly, I think that people would probably choose, if they have accrued PTO, to use that first because they're getting paid a full paycheck. Whereas with PFML, they're only getting a partial. So the thought process would probably be, well, I'll take the PTO that I have first, or the normal thought process, and then the PFML would kick in after that has been used. But that is not something that the employer can decide. That's up to the employee to choose how they want to use it and when.
So can I make them use their PTO? Do I still have the ability to do that?
Rather than well, because right now it's that they can't take the unpaid. They can't take unpaid in order to keep their PTO, correct?
Yeah, that's basically just so guys, don't call out on, a really hard work day because they don't feel like it, and then they save that time for vacation later.
So as I understand it, you can't tell them how to use it. So if
how to use their paid time off benefit that we give them?
Right. So it's up to them to choose whether they're going to use the paid time off or the PFML. So in my mind, that would extend to, you can't tell them.
I can't make them use their sick pay.
Right.
I suppose I could make them use their vacation pay.
Well, the way I understand it is any of the leave that they otherwise have through your company is up to them how they decide to use that in conjunction with the PFML.
So I as an employer, I kind of just lost a right here.
Essentially.
Okay. Thank you.
Okay. All right, let me get back to anybody else?
This is Andrea from Resourceful. I sent similar to Jackie's question, just wondering how this overlaps with other leaves, but I also said disregard if we're going to get there later.
Yeah, I'm going to cover it a little bit more later, and then maybe we can talk more about the. And one thing to keep in mind too, although the state has pretty clearly said that you can't tell them how to use, their paid time off and that, the state doesn't appear to know how to handle the interaction with FMLA. I mean, we do have some information on that, but we suspect there's probably going to be some challenges around that while it gets sorted out. Just because some of the things that relate to PFML are different from FMLA. So I'll cover a little bit later on some of that, and then we can take some more questions on it. So as I'm sure everybody knows some of this stuff already, but I just, to make sure, like I said, as I have ongoing conversations with people, sometimes there's still some questions. So the premiums that have been being collected are 0.4% of gross wages, and the gross wages can include paid vacation, bonuses, commissions, and stock as compensation. The total premiums being divided between employees and employers. And employees, like I said before, are paying the majority of that, 63.33% of the total premium, with employers paying the remaining portion. And if your employers with less than 50 employees do not have to pay the employer portion, but you still must collect and remit the employee portion and comply with the reporting requirements. And then some employers have chosen to pay all or part of the employee portion as a benefit to their employees. Because as we know, with some of this happening, employers are running out of benefits to provide to their employees. So this isn't a huge one, but I do know some instances where employees were happy that that was being taken care of, even though the employer wasn't necessarily required to pay it. Meaning in the instance of 50 or less employees. So if an employer fails to deduct the employee's share, then the employer is considered to have elected to pay that portion retroactively. Now, moving forward, of course, if they then start deducting the employee's share, then they're fine. But the retroactive piece that wasn't paid on behalf of the employee will be paid by the employer. And you can't deduct that out from any future paycheck for your employees. And then the withholdings are capped at the Social Security cap. And employers should have been collecting these premiums starting in January of this year, and remitting those premiums and providing the reporting to the state as of, let's see, it ended the second quarter. They were supposed to start reporting in the first quarter, but the state didn't have everything up to date. So so as far as determining this business size and what you're required to pay or not pay, that's calculated once per year, and it's based on head count, not FTE, and it will be determined in September every year, and they'll look back at the last 4 quarters of reporting to determine that. So for this year, they just used the first report of the year because they didn't have any prior information. And again, any of the reporting for this year should have already been submitted for Q1 through Q3. So this is a separate report that's being submitted from unemployment, but they're using the same calendar for that. One thing that's been mentioned, and again, this is one of the areas that they've provided these guidelines, but until they actually start implementing it, we don't know exactly how this is going to work. They are providing some help to small businesses related to the costs associated with people taking the PFML. So employers with 100 or 150 or fewer employees, or employees with 50 or fewer employees who choose to pay all of the premiums, meaning those they're paying the employer portion as well as remitting their employees portion, are eligible for these grants. There's grants of $3,000 if the employer is hiring a temporary worker to replace somebody while they're on leave for 7 or more days. And then there's also grants of up to $1,000 to reimburse for any significant wage-related costs that are related to that leave. And apparently, if you start out and you're not going to hire a temp worker, but then later decide to, you can use the first grant, the $1,000 for reimbursement, and then request the difference if you do end up hiring a temp worker. And so you could still get the full $3,000 assistance there. And then you can't receive more than 10 grants per year and only 1 for each employee that's on leave. So if you choose, one thing to note too, if you choose to pay the employee premiums in order to participate and receive these grants, you then agree to pay those premiums for 3 years. So it's not a one-time thing where you know that you have that situation for that year. You actually have to continue to pay the premiums for 3 years. And employers can have voluntary plans, and it can be just for family leave or medical leave or both. They must meet or exceed the state program, and they must cover all employees. So all employees meaning full-time, part-time, seasonal, and temporary employees. You can't just choose a particular group of employees within your organization who are covered by the voluntary plans. And then you do have to have the plan approved in advance by Employment Security, and they will be charging a fee of $250 for any plans that are submitted. And then that plan has to be reapproved for 3 years by Employment Security, and it would become effective in the quarter following the approval date by them. So as I mentioned, the job protection component is a little bit different in that it doesn't apply to everybody that's taking PFML. There are 3 factors that must be in place for that to occur. So the employer must have 50 or more employees for 20 weeks or more. So that's a different calculation than what's used to determine whether or not you are above the 50 employers for the premiums. They look at specifically, have you had 50 or more employees for 20 weeks or more? And then the employee who's seeking the job protection must have worked with that employer for at least 1 year. So this wouldn't apply necessarily with some of the part-time employees because they wouldn't have this, they may not have this requirement filled. And then the employee must have worked 1,250 hours for that employer in the last year. And interestingly, and again, this is something that we're wondering how it's going to work, but the employer, once they determine that they won't be providing job protection to a particular employee, must notify that employee. And that occurs even if they're on leave. So if somebody goes out on leave and then you decide, well, I'm not going to hold the job open for them, the employer is required to provide notice of that. One of the discussions we're having here is it seems like that's probably something you should know before the person goes on leave, and how will that affect how a person may or may not decide to use that leave, and whether that could lead to some issues around how this requirement works in preventing people from maybe taking the leave because they're concerned they might lose their job. So that again is something we'll have to watch closely and see how it's implemented. As I mentioned, the business size is calculated a little bit differently than for the premiums. And then you can, if a person's out on leave, you can require them to report in periodically, just so you have an idea of what their plans are. And again, that would relate to the job protection piece, because if you're holding a job for somebody and find out they have different plans, then you may want to change what your plans are. So one thing that we've also been talking to people about is checking in with their insurance carriers regarding any short-term disability coverage they might provide to their employees, because it's possible that in some instances, depending on the policy, it may not be necessary to carry it anymore if it doesn't actually provide an additional benefit to the PFML. So it's a question to talk to your carrier about and how it works with the leave. There are some coverages that will simply reduce the amount of benefits based on what they're already getting from PFML. There are some where it may not come into effect until after they've used their PFML. So again, it's a conversation to have with your carrier to figure out what you currently have in place. One concern being that if it's something that you've already been offering, you may not want to take it back because it has been something you're offering. So just again, getting more information about what your policy looks like and how it interacts with the PFML. And an employee, if they may want to use the short-term disability before they institute the PFML. So again, it goes into them figuring out how to optimize what they're doing with the benefits that are available to them. And there is, certainly the possibility that the premiums will go down because there's not as much risk that they're going to be paying out these benefits. So. Okay, so here's the fun stuff. So like I said, unfortunately, the state is not providing a lot of guidance as it relates to FMLA. An employer can run it concurrently. So if somebody qualifies for both, the employer can log it as FMLA. But as I mentioned earlier, Jackie, we can't require the employee to use any accrued paid leave, which is different from what the FMLA requires or allows. So there are things like this that may bring up issues, and they may have to figure out ways to address them because they don't necessarily make sense. So, and again, it's up to the employee to choose between their vacation, their PTO, and their sick time. So the employer cannot require them to use certain benefits first, last, or second. It's up to the employee to decide how they want to do that. So they could decide, and again, I'm not sure what the purpose would necessarily be, but they could decide to use the FML prior to using the other time. And it's also possible that an employee could qualify for the paid family medical leave, but not for FMLA, given that the definitions within the PFMLA are a lot broader than FMLA. And they could also use, for instance, if they use the FMLA for the birth of a child, but then they have an in-law who's sick, they could use the PFML for that. But again, this is something that's not, the state really isn't commenting on, other than what has to be provided under PFML. Any questions on that?
This is Andrea. I just have a quick question. So, typically whatever is the most generous for the employee is the one that is used. So is that, if PFML and FMLA run concurrently, is that the case here, that you'd have to let them decide how they use PTO? Since you can't dictate for FMLA, but you can't dictate how they use it for PFML, but you can for FMLA. So if they're running concurrently, is it the more generous, which would be that you can't dictate because of the PFML?
Yeah, that would be the case. You'd have to comply with that. But I think that's where the things are where there may obviously issues are gonna arise, because the two don't mesh.
Right.
So again, these are situations that could potentially lead to problems, we suspect, and unfortunately, it could be a couple years before we have some certainty around exactly how that pans out, because you're doing what you think you should, as far as, okay, we have to comply with the PFML, and therefore we have to allow them to choose. But if it's running amok of the FMLA, then there are going to be problems, and they're going to have to address that somehow.
Yeah.
This is Jackie again. I have a very what if the sky falls mentality. So with that framing my question, let's say an employee has a leave and they don't want to use their sick time. And then everybody's happy with that until somebody's not happy, and they come back and say, you employer should have paid me my sick time, why didn't you? Can I fall back on my, form I have them fill out saying they don't want it, or am I going to be on the hook then later, or how does that work?
Okay, so lead me through that again. So they're out on leave.
And they don't want to use their sick time. And then they come back later and they say, well, I changed my mind. I did want to use sick time. Am I going to be on the hook for that?
But but you're saying they're already collecting PFML?
Yes.
No, because they chose by making the claim for PFML, that's what they chose to do.
Okay. So can they do both? Can they get sick time and file a claim?
At the same, no. It would be, they'd stack it. So they would have to choose which one they're going to do. And
okay.
They could use it. So that's why I don't think that it would surprise, well, I'm not sure. Again, I say this and of course people always surprise me, but to me, if you can get full payment from your PTO, your sick time, then why would you choose the lesser? But the other thing, Jackie, is I have a feeling that employees, you know, of course there's notices and things that are going to be going out to them to explain all of this, but I don't know that they're going to fully understand.
I anticipate garnishments for use my sick time on paid family leave. I for sure 100%.
Yeah, exactly. So it's going to take a little bit of time to get that worked out.
So they can't get PTO and they can't double dip then?
Correct.
Okay.
So they can't, sorry to interrupt, they can't use both as long as it doesn't go over their, like, equal more than their usual wage, or they just simply cannot, like right now you could use short-term and PTO just to get up to your normal wage. So they cannot do that?
Correct. They have to use it. So they have to say, okay, I'm going to take my vacation time and then I'm going to use PFML. They can't. Now there is discussion, and this is part of the final rulemaking process related to supplemental benefits that employers could choose to provide, or if they already provide, that bring them up to that 100%. Now, as far as the short-term disability, though, I think that's a different question, because that depends on that policy.
Where's the line as an employer for me to say, you know, to point these things out to employees? Like, say I get notice of a claim and then I get a request for sick pay. Can I just say, can I be the cop and say no? Or do I have to pay that?
Well, you wouldn't pay it, because they're already getting the, so that is a question that's also come up around the supplemental benefits, because as I understand it, there's not really a mechanism by which the state is verifying whether or not the employer is paying anything, and or the employer knowing how much is actually being paid by the state. So, I mean, it would be similar here, right? There's no verification either way. Although, if you're reporting what they've worked, then that may be one place. But I'm not confident that that the state will catch it there.
So I am 100% within my rights as an employer to deny somebody their sick pay if they have a claim I know about, and I'm not going to get in trouble with sick pay laws.
No, because they're already receiving benefits.
Okay.
I'm going to look, Jackie, about if they've provided like the best mechanism by which to do that. You know what I mean? As far as how because the other thing, I know that you're going to be required to put up the workplace posters, and there's certain notices that are going to be provided to employees as to what their rights are. So, you know, to figure out the best way for you to say, no, you're not getting it, and this is why. So let me look at,
okay.
And I can send
and I imagine there would be some kind of, just like, you know, the ESD and LNI, you know, send employer verifications, you know, I would foresee a question, did you pay this person PTO? I hope they do something like that. That would be a pretty easy way to catch it.
Yeah, unfortunately, I have not heard or seen anything like that. So,
from the government?
Huh? Sorry. No, I'm meaning related to this specifically. I haven't heard them talking about, you know, they do, other than saying we're giving the employer notice that the claim's been made, that it's been approved or denied, you know what I mean? So
they'll figure that out down the road.
Well, yeah, because there's going to, like I said, there are going to be issues that come up, and then they're going to have to figure out how to deal with them. So,
okay. Well, thank you.
Yep. And I will look at the L&I thing. I appreciate that. I unfortunately did not think about that as a, how that would interplay. That'll make it good and messy with light duty and everything.
Yeah, kept on salary. What? Ugh.
Yeah. Okay, so the things that we're talking to people about right now, and we keep kind of pushing some of this out because of course the rules keep not getting finalized, but it is probably even now, and you may or may not want to revise them right now, but just having the information that you do, looking at what your current leave policies are to see how they interact with the PFML. I mean, there's even, a chance that you may want to not have them be as generous as they've been because of the fact, that you could end up with somebody being out for a pretty long period of time. There was an example provided on one of the state webinars where an individual took, there was paid maternity leave through her employer of 12 weeks. So she took that and then also took the 12 weeks through PFML. So just kind of looking at those and deciding, what your company wants to be providing to the employees. And again, may holding off until the December rules come out just to confirm, because like I said, one of the things identified there relates to supplemental benefits, for example, topping off the benefits that they're receiving. And given that, from what I've heard, the state doesn't have a lot of mechanisms for verifying what's being paid by the employer if they choose to supplement, and then the employer may or may not know for sure what the benefit that's already being paid. So we would, we want to encourage people to look at their policies and potentially revise them, but it may be best to wait until after the rules come out at the end of December. And then also, and this is, we recommend this on a regular basis anyhow, as far as FMLA, but also ensuring that your policies are complying with the PFML. And whether, like I said, whether you're providing appropriate benefits or not, if they're too generous, not generous enough. And some of this is just decisions made by employers. Some people may want to allow somebody to take a total of 24 weeks of leave. But it's an individual decision for each employer. And so just being able to start looking at that now and getting ready to make any necessary changes, because you're also going to need to notify your employees once those changes are made. And like I said, some companies are looking at whether or not they want to top off the PFML benefits to bring them up to 100% of their wages. So the comment that I heard was they're pretty much going to rely on an employee who's declaring under penalty of perjury that this is what they're receiving as far as benefits or from the state versus their employer, and not really much way for the employer, at least at this point, to confirm what benefits being received. They're saying that there may be some privacy issues around that, which I understand, but if you're wanting to pay benefits, then there should be some way that you can confirm you're not paying more than you need to. And again, just trying to be strategic about how you're approaching these policies, and maybe using them as ways to find other value to add to give to your employees. And getting with your short-term and long-term disability carriers to see how those interplay and whether you want to make any changes there. And getting ready to have employees who may start using the program, and what do you do to prepare for that, whether you need to bring in other employees, temps, that sort of thing. And again, as I already mentioned, looking at your policies and your handbooks, probably in Q1, early on, once the rules are out. And also double checking any deductions that are being made. I know a lot of people are using payroll companies and that sort of thing, but I have run into situations where the accountant didn't necessarily understand how the premiums were supposed to be calculated. And it's, it's not necessarily a huge amount, but if you have quite a few employees, it could add up. I did have an employer recently who told me she was having to pay some people some money back. So just reconfirming that, not necessarily assuming that it's being done correctly. And then the state is going to have available, not really sure when, but we can keep people apprised of the workplace poster that's going to need to be posted, as well as the notice of rights to your employee regarding their ability to use the program for their leave. Does anybody have any other questions?
This is Andrea again. Just wondering if, and again, I'm sorry if you touched on this, but if employers haven't reported, will they be notified somehow, or will that just come up if an employee requests the assistance?
Yeah, I don't know the answer to that question. I can see that being the case where the state may not be in a place yet where they've realized people aren't reporting. And then it would be logical they'd find out because somebody applied. So I haven't heard that they're reaching out to employers. Okay. And it wouldn't surprise me if they're not, just given what they've been busy trying to get done. So, but I would say if you're an employer that hasn't done that, I'd get it taken care of sooner than later.
Okay, and this one is probably a little far-fetched, but just you may or may not know this, but if somebody owns their own business and then they scratch that and go work for an employer, does that time count as hours worked towards the 820, or does that have to be for an outside employer?
You know, I don't know. I am trying to think back because I did have a conversation with somebody that was self-employed. I don't know for sure, but I can check on that.
Okay. And I guess my last question is, do you know if, and if not now, do you know if there will be like a model policy somewhere out there that's already been put together?
No, they've said that they will not have that's up to the employers to figure out.
I figured, but I thought I'd change it.
I did hear that question asked, and they said, you know, they'll have the poster and they'll have the notice of rights, but they weren't necessarily providing any policies for people to use.
Okay.
So I think I mean suspect that's probably because, you know, different employers are going to want to address it differently, right? So it's probably hard for them to come up with something specific that would really be that you could just provide in general. But.
Is there going to be another class after the next rulemaking?
Yeah, so what we're going to do, Jackie, is our understanding, and hopefully they stay on schedule, is that the last rules will come out or be published December 20th. And I believe that's a Friday. And we have already planned to do another webinar on the 23rd.
This is Laura. I have a question. Just curious, there's all this stuff you said that on the 20th they're supposed to tell us this, and on the 20th they're supposed to tell us that. Based upon your experience over the past 12 months of them trying to figure this out, which based upon what you're saying, there's a lot that hasn't been figured out. What is your confidence that the 20th is actually going to answer a lot of these questions that we as business leaders legitimately have about process and communication between the different parties? Or are we literally going to go into 2020 just on a hope and a prayer?
So most of what is involved as far as the December 20th relates to the supplemental benefits. As far as the filing of the claim, we already have that process. But I do have to say that I don't have a lot of confidence just because they have had to move dates out. But that's also on them and recognizing that they have to allow employers some leeway because of that. So, but again, my understanding is that a lot of what's coming out at the end of December relates more to the supplemental benefits and how that gets handled. So hopefully most everything else, you know, of course there's going to be growing pains in getting through some of that. But my understanding is as far as the process for making the claim and how they're going to notify employers. Now, and I apologize, the one other thing is, of course, whether or not employers are going to receive certain information about the benefits that are actually granted. But I'm not sure that that's necessarily part of the December 20th rules. That may be something that's ongoing, because there's some privacy issues they're looking into on that. So, but again, that's not something they can hold the employers to if they haven't figured it out. So.
Thanks. I appreciate your optimism. I don't think I'm in the same optimistic world as you are.
Well, and that's, you know, we've struggled because when we hold these and, you know, are concerned that we don't have that much information, but I think it helps just having at least some information, right? And we're trying to work through it together and figure out the next steps. So just trying to be proactive about it to the best of everybody's ability.
I think it'll be interesting because, you know, you want to look out for the employee. You also want to look out for the employer. Everyone's going to feel, you know, what's the right word? Unfairly treated.
Right. Well, that's why we anticipate lawsuits around it. Yeah.
Yeah. And I guess it's just for employers to be a little more, just, you know, documenting more than they normally would, or feel like they need to, just especially the first year or so.
Right.
Conversations and requests and forms and stuff like that. So that might be make sure people are getting all their leave of absence request forms up to date and policies, as you've said. So, but the information's been helpful, definitely. So
good. And like I said, feel free to, I'll look at these couple of questions that I didn't have answers for, and we'll figure out a way to include them with the follow-up email sending the recording, so that you have those as well. And feel free to reach out if you have any other questions.
Excellent.
Or want us to look at policies or help with that. But like I said, and unfortunately with the policies, we've actually said that a couple of times this year where we think it's important to start looking at them, but you may not want to make any revisions yet. Because we don't want people making 3 or 4 revisions that they don't necessarily need until it's all kind of in at least a little bit more solidified manner. So. Cool. So anybody else?
Thank you.
You're welcome. So like I mentioned, we are going to plan to do another webinar on this after the December 20th rules come out, and of course if those get moved out, we'll let everybody know and let you know when we're gonna really try to have a webinar within a couple days after that happens, so that we can keep everybody in compliance as soon as possible. And then the other thing, we are doing another webinar. It's our usual focus event in December, but it's a year in review. So it'll cover some of this, but any other changes in laws that'll be important for employers to know. So that's December 18th. And I think some of you may have already actually signed up, but we will send that information around, and you can sign up on our website right now. So I hope you can all make it to that as well. All right. And like I said, if you have any feedback for us on this format, please let us know so we can make changes as needed to make it a usable format for everybody.
Where would you like that feedback?
If you want to send an email, that would be great. I don't know.
Or we could just reply to maybe the email you're going to send out.
Yeah, that works too. That would be great.
Great. Excellent.
Okay, great. Thank you all.
Thank you very much.
Have a good day.